The Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. Ed, please call the case.
Good morning, Your Honors. The matter before the court today is the case entitled Julio Davila versus Nicholas Deml, case number 24 AP 191. Representing the appellant, Julio Davila, is Dawn Siebert. Representing the appellee, Nicholas Deml, is Robert Menzel.
Okay, thank you, counsel. Come on up. Please, for the record, introduce yourself and identify your client.
Good morning. My name is Dawn Siebert, and I represent the appellant Julio Davila.
Thank you.
Prior to absconding from furlough, Mr. Davila was serving a 20-year sentence pursuant to a Vermont minimus. When DOC issued a warrant, his sentence was tolled pursuant to 28 VSA 808E. When the warrant was served and he was arrested on August 10th, 2022, that arrest and return to custody triggered the resumption of his Vermont sentence. And that's why the court must award him the 490 days of credit for the days he served in Massachusetts after his arrest on the Vermont warrant.
So you are arguing for all of the time between August 10, 2022 and December 13, 2023?
Yes, I'm asking for an order that he be credited for the time he spent in Massachusetts unable to post bail. There's a slight error in the record. He actually was not held without bail at all in Massachusetts. Massachusetts has a different sort of system. He was arraigned on August 10th in the district court on a complaint, and he was held for lack of $20,000 bail on the fugitive petition and on the mass charges, $20,000 separately.
So what's the December 10, 2022 date? How does that play in here? Does that make any sense to you?
So December 10th, I'm not sure what date you're referring to, Justice Reiber.
Well, there was a point in time, I thought, after he was unable to post bail, that under the Massachusetts bail law, he was free to go. Isn't that December 10, 2022?
Massachusetts reduced his bail to release on his own recognizance on December 12th, 2023. And that is when he returned.
So I don't know what that date is.
Yeah, that's when he returned to Vermont, Justice
And
Reiber.
that's when the Massachusetts charges were dismissed, right? The suppression hearing, there had been a suppression hearing and he prevailed with the suppression hearing that was appealed. And then ultimately the Massachusetts District Court then, or the state moved to dismiss, is that right?
Yes,
Okay.
yes. And so 28 VS.
Can I just go back to one thing?
Sure.
That I didn't realize that you noted to us in the record. So, Mr. Davila was held on $20,000 bail that was imposed by the Massachusetts District Court for both
Yes,
Massachusetts charges as well as the fugitive petition.
yes,
Okay.
yes.
When was that imposed, the 20,000? Because it's not clear to me from.
August 10th, 2022, the day he was arrested.
Okay, so the fact that there was, someone said there's no bail due to the out-of-state warrant, that was not correct?
That was not correct. There's 4 dockets in this case. There's 2 district court dockets for both for the new charges and the fugitive petition. And then there are superior court dockets. In Massachusetts, the district court docket is dismissed when the defendant is indicted and the case is sent to the superior court. So there's 4 dockets, and they clearly show that he was detained for lack of $20,000 bail on August 10th on each docket,
Right.
which
And
is why.
I'm sorry, that continued on until December the 12th of 2023, the 20,000 bail.
Yes, yes. And so 28 VSA 808E denotes a period, a tolling period during which the offender does not get credit against his sentence. And that period is when the warrant is outstanding. there's a start date to that period when the warrant is issued and an end date when the warrant is served. It's not open-ended. The statute doesn't say that the person stops getting credit when a warrant issues. That would be an open-ended statute. This statute denotes a period, and the period is very clear. And it's not just semantics. When the warrant is served, the person returns to prison. So that's why that period when they're sort of on absconding status, that's told. But once that warrant is served and they come back to prison, they begin to earn credit again.
But
And the
don't you have to read 726 and 808 together? And in 726, it says that an offender will get credit when being supervised by the Department of Corrections. Even if they're not in prison anymore, they're being supervised. And he certainly wasn't being supervised when he was outstanding and not reporting.
And we're not asking for credit during the period when he was not reporting. But once he returned to prison, no, he's not getting credit under the furlough statute. He's getting credit under the statute that awards credit when someone is serving a sentence in prison. And with furlough, the hearings to determine furlough violations are always post-deprivation. So sometimes, with parole and probation, someone will get a pre-deprivation hearing. With furlough, they're always arrested first, and then the hearing is held afterward. So once that person is arrested on the warrant or the furlough violation, they're no longer on furlough. They're serving a sentence in a prison. So we're not asking for credit under 726, the furlough statute. We're seeking credit because he was literally serving a term of imprisonment at that time. And the trial court's reasoning and the corrections reasoning, the court has to reject that because it creates an impermissible classification based on indigency. And since the Supreme Court decision, Williams v. Illinois in 1970, it's been clear that states cannot create two classes of defendants and have a class of defendants who are unable to post bail that end up serving more time on their sentences. And this is how this plays out in this case. If Mr. Davila had been able to post bail on the Massachusetts charges on August 10th, he would no longer have been held on those charges. He would have been held on the fugitive warrant. And at that point, even given corrections reasoning, he would have started to get credit. He then would have waived extradition, as he did, and gone back to Vermont. He would have gotten credit for every single day because he was able to post bail. And then
I'm sorry
Go ahead.
to interrupt you. In 7031,
Mhm.
it says that a person gets credit when he or she is awaiting transportation.
Mhm.
And was he awaiting transportation? He wasn't sitting in Massachusetts because he was waiting for someone to come get him. He was there because he had pending charges there.
He was there because he couldn't post bail on the pending charges. He knew because he was in close communication with corrections. And if you look at the printed case, page 18, he was filing grievances with corrections saying, why aren't I getting my credit? And they told him, we'll give you the credit when you come back. So he knew if he bailed out, even under their reasoning, he would have gotten credit. So he was awaiting return because he had waived extradition. But the problem is the court's reasoning creates this classification where if he could have posted bail, he would have come back, right? And then under the trial court and corrections reasoning, he would have gotten credit. He then could have used the interstate agreement on detainers to go back to Massachusetts and resolve that untried indictment. And under the interstate agreement on detainers, statute 28 VSA, I think it's 1505, he would have gotten credit for under the IAD, you get credit for the sentence you're serving in the sending state when you go to the receiving state to resolve the indictment. So if he had been able to post bail on August 10th, he would not have missed even one day of credit. And so the trial court reasoning creates this classification where he loses the credit on his sentence because he was indigent.
So a slightly different tack. This was decided on summary judgment.
Yes.
Are you arguing at all that there's a disputed fact that destroys the court's analysis.
The only fact that I'm saying is incorrect, it wasn't disputed, is that he was held without bail. Which again is why I'm asking the court to hold that he's entitled to credit for the time he was held for failure to post the bail.
Right.
I can then correct the record with corrections as to when that date, when that triggering event happened.
So there's no
There's no
dispute
factual
over.
dispute in the record between the parties. This was solely an issue of law
Right.
that the court decided. So the trial court and corrections rely on State v. Co. And Co is not on point for two reasons. First of all, it was decided under a former version of the statute. And that former version of the statute contained a limiting factor, the phrase in connection with the offense. So you only got credit for time you served in connection with the sentence for which you were seeking credit. And the court in Co said defendants' claims depend on the meaning of the words in connection with, as they are used in 7031. The statute was changed in 2013, and it was changed to broaden the availability of credit. So the words in connection with were removed in 2013. And after 2013, the way the statute reads, basically, if you are charged and you serve time in prison after you're charged, you get that credit when you're sentenced. If you are sentenced and you serve time in prison, pursuant to a met after you're sentenced, you get that credit against your sentence. And so the amendments in 2013 were intended to broaden the availability of credit so that people got credit for every day they spent incarcerated.
So, Ms. Siebert, doesn't Co rely on subsection B, which is pretrial credit? And that's vastly different
Yes.
from post
Yes.
sentencing credit. Okay.
Yes, that is
Sorry to
correct.
interrupt. Okay.
Co also doesn't raise this classification based on indigency because the defendant in Co was seeking credit for a sentence that he served in New York. The opinion is clear that he wanted credit for time served after he was sentenced. So there was no indigency issue in Co. He wasn't held without bail. He merely had served a sentence in New York and then was trying to get credit for that here in Vermont.
Doesn't Coles establish a burden of proof on the person trying to get credit?
If code does, then we have met it here. I mean, again, the phrase in connection with has been removed from the statute. So the statute is much more akin to a strict liability. If you're in jail post-sentencing, you get credit on whatever MIT you're serving a sentence under. If you're in jail pre-sentence or pre-conviction on a charge, you get credit for any days you serve after that charge. So the amendments really lighten the burden. But to the extent that there is one, we've met it here.
Thank you.
If there's no further questions, I'll
Right.
reserve.
Okay, thanks.
Thank you.
We'll hear from counsel for the appellee, please. Come on up, introduce yourself, identify your client.
Good morning, Your Honors. Robert Menzel for Nicholas Deml, Commissioner of the Vermont Department of Corrections.
Thank you.
This court has historically and consistently held that supervised individuals who abscond from supervision in Vermont are not entitled to credit for time served in another jurisdiction when they've engaged in new activity that's resulted in criminal charges.
So if he was just picked up in Massachusetts on the Vermont warrant and came up on the computer, and he's held in Massachusetts waiting extradition, that would count for, he would be allowed credit.
He would.
And, but the difference here is that there was actual Massachusetts charges that were pending, and and he's being held in Massachusetts based on $20,000 for the cash.
Right. And just to correct the assertion that he was never held without bail, if you look at the printed case on page 44, he was held without bail initially. The last sentence of the first paragraph on page 44, it states that Clerk Ken Chaffee ordered him held without bail due to the outstanding Vermont warrant. So he was held without bail initially, and then when he was indicted in the Superior Court, the court imposed a $20,000 cash bail.
When was that?
What was
What
the date
date?
of that?
The date that he was arraigned was October 28th of 2022. So the
Are you contesting that he should get credit between his initial arrest and August 18th?
Yes, we don't believe that the department doesn't believe that he should get credit for any of the time that he was in the custody of Massachusetts pending the resolution of his.
Well, what about the argument that the appellant's making that he was indigent after the $20,000 bail was established? What about this argument?
So that, I mean, that's going back to the fact that the department works off of the minimus that is received from the court. And the fact that he was indigent doesn't really play any factor in the department's calculation of sentence credit based on the minimus that comes from the court.
Should it?
But the original hold without bail was based on the fact that there was an active Vermont warrant, was it not?
It was based in part on the fact that there was an active Vermont warrant. I mean, obviously, he wouldn't have been in the.
He wasn't bailable. He
custody.
wasn't bailable under the fact that there was a warrant from Vermont, they absconded from furlough. So he wouldn't be bailable for that, but the crimes he committed in the Commonwealth were clearly cases where he could have been, where he was bailable.
Sure, and they set the bill. So,
So doesn't the result of your argument here, in light of what happened in the Massachusetts actions, result in him having done a bunch of dead time?
well, I mean, I think that's kind of a pejorative term for the time that he spent while his cases in Massachusetts were pending. But from the department's perspective, there are consequences for absconding from furlough supervision. Just to reiterate what the underlying facts are here, Mr. Davila was released into conditional reentry furlough, which is kind of a unique program in Vermont that allows individuals who are incarcerated to serve portions of their incarcerated sentence in the community, not in a facility. And despite being given that opportunity, Mr. Davila absconded from supervision with the state of Vermont on April 19th of 2022. He then fled the state, which is another violation of his furlough, and went to Massachusetts, where he was apprehended by authorities on August 10th of 2022 with a trafficking weight of cocaine in his possession. So, that there is that term of dead time, but the department doesn't really view it as dead time. It's a consequence of his having violated his conditions of furlough and then committed a new crime while he was absconded from furlough down in Massachusetts.
But there's no dispute. There's no dispute whatsoever that he violated the terms of his furlough condition.
Correct.
And we've listed at least 3 bases for that: leaving the state, getting arrested in Massachusetts, and not being in compliance with the furlough order.
Right.
So he then gets arrested in Massachusetts and he's held there. Why should we just distinguish out the fact that there was a pending Massachusetts case when Massachusetts could just held him until he waived?
That's not a completely accurate reason of or rationale of what happened. As Attorney Siebert mentioned, Massachusetts has a slightly different system where all the cases get originally brought in the district court through complaint, and then cases that go on to become felony cases are brought to the grand jury and indicted and then brought before the Superior Court. So what happened was he was initially held on the district court information, and then subsequently his case was presented to the grand jury. They returned a true bill. He was arraigned in the Superior Court on October 28th. In the middle of all that, he waived extradition. But if you read the statute closely, that doesn't mean that the warrant goes away. 808E.
I'm sorry, let me just interrupt you for a
Sure.
minute, because you said something that was interesting to me. So the process you're talking about, I'm familiar with because I was a former prosecutor in New York City. It's the same process. Someone gets arrested, held on the information.
Right.
Whatever judge decides on the arraignment of the complaint, and then once they're indicted, then they go back and it's another arraignment. So when he was arrested on the information or the complaint, was he held at that point without any bail, or was he held on the warrant issued by the Department of Corrections in Vermont?
So it's difficult to parse out the exact detail of that, because when you look at that sentence that's in the printed case at page 44, it's a one line at the end of the first paragraph of that page. And the officer reports that he contacted the clerk held him without bail on the Vermont charges. And so it's not totally clear whether
It
that
says on the Vermont charges, though, held without bail on the Vermont charges.
well, held without bail, but then based on the Vermont warrant. So
Okay.
so I think, there's an inference that he's held on bail. He's held without bail on both pending the arraignment in the Superior Court, but maybe I
Do you know where
could
that
be
is in the
wrong.
record?
What's that?
Where is that in the record, Mr. Moore?
It's on printed case 44. It's
It is,
the
okay.
last sentence of the first
So
paragraph.
why shouldn't he get get credit for the time up until bail set on the Massachusetts charges? I'm not getting. You seem to say that it's because he's not being supervised by Vermont, but what sort of supervision does he need when he's in jail?
So the language surrounding the warrants, though, if you read the entire text of the statute regarding the warrants, that actually requires the individual to be returned to Vermont authorities. The warrant doesn't expire once the waiver is served. The warrant stays in place until the body is returned to Vermont. If you look at the actual return of the warrant, which is at PC 41, the date that the warrant is deemed to be returned is 12/13/23, when he's brought back into custody of the Vermont authorities when they pick him up. Because the bail was reduced to personal recognizance on December 12th. Next day, the department was down there picking him up, or representatives of the state were down there picking him up on the warrant. And that's the date that's on the warrant as the return of warrant. So that warrant is still outstanding. And so
your timeline, I'm sorry to interrupt you again. Your view, the department's view, is that it's not when the warrant is executed. And here it was executed on, what was that date? October. I'm sorry, excuse me, August 10th, 2022, when he was arrested, right? Is that
Right.
So? We should not, under your analysis, be focusing on when it was executed, but rather when his credit runs, it would be from the time that it was returned on the warrant, which would be December 13th, 2023.
That's the department's
That's your
position.
position.
Yes, Your
Okay.
Honor. So because that is going back to the co-decision, it is slightly different. The pre-sentence credit is kind of a misnomer, because when you do a closer reading of Mr. Coe was actually being returned to Vermont for a violation of probation. So he was being sentenced in connection to his violation of probation. So the court characterized it as pre-sentence credit, but it's really wasn't really pre-sentence credit in that sense, because he was coming back on a violation of probation charge, and that's sort of analogous to the return for a furlough violation. So, and in terms of the amendment, this court had an opportunity to address the co-holding of the sole custody holding in in the Fleming-Panchione case, which was decided by the case in 2017. And the court in Fleming-Panchione held that the petitioner had failed to establish that the time he spent in Massachusetts was related solely to the Vermont charges, as required by our decision in State v. Coe. So this court had adopted the sole custody standard that had been set out in Coe subsequent to the amendments in Fleming v. Panchione. And I think another line that comes from Fleming-Panchione that we need to keep in mind is that when making these analysis, the court has to apply all the statutory sections together as a whole, because what's happening here is that Mr. Davila is attempting to pick out pieces of each of the statutory provisions to make his case. But when you read the statutory provisions as a whole, it doesn't hold up. 808E is a good example of that. 808E requires that the individual needs to be returned to the custody of the state in order to satisfy the requirements of the warrant. That's
808E say no credit towards any sentence for any days the warrant is outstanding, right? After it was executed here on August 10th, 2022 in Massachusetts at the time of the stop and the car stop and the arrest. Is the warrant still outstanding?
It is, because the
Is it
warrant,
returned back to Vermont?
that would be the department's position. If you look at 808EB, it contemplates that there's a requirement for a return to the state of Vermont. And so, Mr. Davila he's in custody, but he's in the custody of the state of Massachusetts for charges that he incurred while he was in the state of Massachusetts. Vermont has no control over what is going on with Mr. Davila while he's in Massachusetts. He's not in their custody. He's in the custody of Massachusetts state authorities. So
Would you address the indigency issue, please?
I think the indigency issue it's a tough one. I mean, that is, I want to just say that he's not serving a longer sentence because of being indigent, because he doesn't get credit for the bail. The sentence is the sentence, and the credit that he gets within, like him being held on bail, that doesn't make his 20-year sentence become now all of a sudden 21 years, 22 years. His sentence is still the 20 years. The issue is whether or not he's getting credit for the time that he spent. So the contention that it's lengthening the period of his sentence is kind of a misnomer, because it's the same sentence.
But it's going to take him 21 years to do the 20.
Well, if it does take him 21 years, it's because he's absented himself from the jurisdiction of Vermont. And so, the department's position is that the individuals who disregard their conditions of supervision and then flee the state and go to another jurisdiction and commit new crimes should not reap the benefit of time that they spend incarcerated in the other state because they were engaged in activity that resulted.
Well, it's not about reaping the benefit. It seems to me it's about what the law says. And
Sorry?
it's about what the law says.
Right.
We're not talking about whether he's getting away with something or not. It seems to me it's what the law tells us what to do.
And that's the department's position, is that based on the law that's been set out in Coe and Fleming Panchione, this calculation of the sentence credit is correct. The individual doesn't get any credit for custody that he spent outside the jurisdiction of Vermont. He wasn't being held solely on the basis of the Vermont charges. He was being held also on the Massachusetts charges. And so that's the law that the department is using to make the sentence credit calculation. And we'd ask that the court affirm the lower court's decision. Thank you.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 2 minutes, 41 seconds remaining.
Counsel.
Just enough time.
So to your point, Justice Eaton, Mr. Davila will serve 20 years plus 490 days. And 20 years is the statutory maximum for his offense of conviction for heroin trafficking. So he received the max by the criminal court. He will now serve more than the max because he was indigent. And
And the time in Massachusetts that he served doesn't count, obviously, on the Massachusetts cases because they went away, and it doesn't count on the Vermont cases.
Right.
So it is dead.
It is dead time, correct. And also, I apologize for the mistake in the record. I have the docket here on the district court complaint that was filed on August 10th. He was stopped soon after midnight, and it is true that a court clerk held him without bail and after hours clerk. But on the morning of August 10th, he was arraigned and bail was set at $20,000 on both petitions, the criminal complaint and the fugitive petition. So on August 10th, had he posted bail on the Massachusetts charges, he would have been held solely on the Vermont petition. He could have waived extradition and gone back. Two more
But
points.
you started out by saying he would be serving more than 20 years. because of these 400 and something days. But he wasn't serving them. If Mr. Menzel's argument is correct, he didn't serve those 400 and something days. So therefore, it didn't add to his sentence. He's just serving them at a different time than had been expected when he was on a conditional reentry.
He did serve them in prison. I guess I'm.
But
not
if
sure I
he gets
understand.
credit, he served them in prison.
Say it again.
Only if we say that he got
Yes.
credit.
Well, he certainly served them. There's no question that he served those 490 days. You know, had things played out differently in Massachusetts, he might have gotten sentenced, could have been concurrent, could have been consecutive. As it was, the stop was unconstitutional. So he didn't receive credit anywhere, but that's not really the point, because the point is whatever the Vermont statutes say about his credit. And I have two more points I want to make. One is that Mr. Menzel referred to the consequences for absconding from furlough. I just want to point out to the court that Mr. Davila was also charged with escape from furlough, a 5-year felony in Vermont for his conduct while on furlough and in Massachusetts. And so, you know, he has received a serious consequence for absconding in addition to the Massachusetts charge and the time served down there. And then also regarding Fleming Pancione, that case was not actually about 7031. In Fleming Pancione, the defendant was seeking credit for time served before he even committed the offense. And so in Fleming Pancione, this court just said, no, under 7032, even if a sentence is concurrent, you don't get credit for time served before you actually committed the offense. So it wasn't a reaffirmance of the sole basis rule. It was really decided under a different statute.
I know your
Okay.
time is up.
I know.
Yeah,
Sorry
yeah,
to ask
please,
one question.
yeah.
What section of 7031 are you relying on?
Under 7031, hold on a second, let me just go over it. I think it's 7031 that says that the credit starts to run, maybe it's. Okay, so yes, under B, the sentence of imprisonment of any person convicted of an offense shall commence to run from the date on which the person is received at the correctional facility for service of the sentence. And so I'm saying when he was received for service of the 20-year sentence, he was serving the sentence. He then was serving the sentence on furlough. He then absconds and the sentence is told under 808, excuse me, E, while he is, while the warrant is outstanding. When that warrant is served, he begins to earn credit again against the minimus. It's not pre-sentence credit. It's sentence credit for time spent in prison on the minimus that was the basis for the warrant that was issued for the furlough violation.
Is that section C then?
So, I mean, C is relevant because C says basically it doesn't matter where he serves the time. If he's serving a time at a different jail, he still gets the credit while he's waiting to come back to serve the time in Vermont. So C informs how this court analyzes B, but it's basically just he was serving time on a MIT on a Vermont sentence, and so he should get credit.
All right. Thank you very much.
Thank you.
Please call a conclusion.
The next hearing for